So before we started, we decided to call it Wolves at the Door.
Wolves at the Door.
It's very dramatic. So we'll hopefully the content today is going to match the cool title. Welcome, everybody, to FH&P Lawyers Law Talks. I'm Clay Williams. I'm your host, as usual, and we've got a great show for you today. I'm here with Shane Gardner. Shane.
Thanks for having me.
Thanks for coming.
Appreciate it.
We've got a kind of a cool show for you today. It's debtor strategies for businesses in these tough times. So we have on prior shows talked about debtor creditor law and how things might happen, but today we wanted to just kind of focus in on some strategies for your business. When things aren't going well, you've missed some payments, and boy, you've got a demand letter now. You might have been sued, or you've been contacted by creditors. We want to try and give you some strategies on what to deal with, and we're going to start with don't sign anything without coming to talk to us. So why don't we start just by, one of the things I think, Shane, that we see a lot of is when people come in and they've already done something, they've signed something. Yeah. So I think you just had a recent experience with that too. People doing that. Tell us about it.
Well, just today we had a client call in, and I think anyone can empathize right now that the economy's not in the greatest spot. So people are doing their best to try to keep things afloat. This gentleman was doing the same. Trying to do what he could to keep the food on the plate for his family, essentially. And, fair enough, lawyers are expensive, and sometimes we are the wolves, sometimes more gray than others. But at the end of the day, he tried to resolve the problem himself, and fair enough, I get it. But he ended up signing some documentation in an effort to buy time and opportunity, and at the end of the day, ended up spending more of the time and opportunity that he actually had trying to get something that wasn't really worth it at the end of the day. So when he came to us, we're going to do our best to help him. But had he come to us in the beginning, and again, fair enough, no knock on him, we would have been a little bit more able, had a little bit more of our own time and opportunity to try and get him out of the hole that he's in right now.
I think this can't be stressed enough, because we act for creditors too. And what we are always trying to do right off the bat is we're trying to turn corporate debt to personal debt. We're trying to turn unsecured debt into secured debt. And we're trying to add in other debtors and trying to get guarantors, life partners in the door. And so we see this all the time. People are come in and they've already signed something. They think, okay, I'm going to try and deal with this on my own, and I'm going and sign something. And boy, by the time they come to see us, all of a sudden they've turned a corporate debt into a personal debt. Yeah. They've signed a mortgage on their house, or they've added their life partner in. So don't do that, folks. I know that there's a real thought out there that, boy, I'm just going to throw good money after bad if I go and see a lawyer. But boy, we can really take a look at it. So you've got a process, I think, when people do come in. Yeah.
A lot of it too is, when there are sort of the wolves knocking at the door, so to speak, it's a frightening situation. And a lot of the time you don't understand really what the alternatives are. So let's say you have a lender, you're a business, the lender's calling the debt or calling a credit facility. You owe a substantial amount of money and you think, look, I just don't have any other opportunities here. I got to capitulate. I got to sign.
But maybe you do.
Maybe you do. That's exactly right.
Yeah.
So a lot of that is going to be some business understanding. It's going to be looking at the agreements that you've entered into already. But some of that comes with us, and that's sort of the practical realities of the situation that you're in from a more legal perspective. For example, how much time you're going to be afforded just through the reality of the court system, what type of proceedings are available to you, whether you're going to be able to make a proposal. In the larger cases, if you're going to be able to avail yourself of a CCAA proceeding, there's certain instruments and levers that debtors, especially in the business context, can pull in order to buy them that time that they initially sign off for, without really having to sign off on that time and opportunity that they're spending already.
And I'd say there's nothing wrong with asking a creditor to show what they've got. Sure. Because, I mean, I don't know how many times we've seen when, creditors come strong out of the gate, because we do that too, and make a demand and, on the company, and make a demand on the principal of the company. Yeah. And, when we ask to see the credit agreement, it's gone. So it was signed years ago, and they can't find it and something like that. So, one of the things, I guess the first thing that we'd want to do would be to tell you what your liabilities are, find out what the liabilities are, and then proceed from there.
Yeah, like you have to be realistic to a certain extent. And sometimes we work with trustees as well. Like we've got partners throughout the Okanagan, and it's really taking an honest inventory of what you have, what you've agreed to. And with that, how can we strategize from there? How can we build a plan to get you where you need to be? But yeah, it's a very sobering look at the way things are. I mean, the lenders, for the most part, or the creditors, they're going to be doing the same thing on our end. They're going to be doing some mathematical calculations. They're going to be looking at a legal team. What can they do? So we have to do the same thing. But there are opportunities. There are levers available that we can pull.
And I do like if you're in trouble, I'd like to see an exit plan. Sometimes the creditors are coming at you like an avalanche, and it's very scary. It's very hard. But there is a whale, perhaps. There's another lender. There's somebody that can, you just need a little time. And that's where, very often we can assist with that, or at least tell you how much time you've got, and before you sign anything. And, just thinking about that, one of the things that we're talking about is forbearance agreement.
Yeah, forbearance agreements.
Forbearance agreements are something that often a creditor is going to present to you and say, look, you need some time, no problem, sign this forbearance agreement. But boy, that can really, really limit what we can do for you.
Yeah, like the gentleman that I had call recently, that was a situation that he had already entered into. So with that, I mean, it sounds great, right? We're going to give you a little bit more time. Of course, you're going to pay some more interest. But then also sort of hidden in the smaller terms was, for example, you're going to turn this corporate limited debt into a personal debt. So he's giving up much more than he thought he would, under the understanding that, hey, look, I'm going to be able to crawl out of this. And that goes to our initial point, which is, are you actually going to be able to? And also, what time do you actually have that the realities of the situation are going to afford you?
You're going to agree to the amount of the debt. You're going to waive all your defenses. You're going to make big payments. It's just, it's very, and that's tough in the agony of a business not being able to make its debts, that maybe I'll sign this, I get a little time, but we'd urge you not to. We'd urge you to come in and get an assessment on that before
absolutely.
You do that.
And sometimes it's not, I mean, we make it sound like it's this big dark cloud, but sometimes it does make sense for both parties, and sometimes the forbearance agreement is the answer.
That's a good point.
If there is an honest chance of you crawling out, or if there is an honest chance of you recovering or making good on let's say a defaulted credit facility, then fair enough. And if the bank is, or I should say any lender, is willing to give you additional time, I've seen it work, right?
Yep.
But you want to be careful. Point. You want to be careful, right? On both ends. Like you said, sometimes we're acting for the lenders as well. But just because it sounds good doesn't necessarily mean it is, and just because we're scaring you a little bit doesn't necessarily mean it's not a viable option. But ultimately, underscored, redlined, highlighted, you want to be careful, and that's where we can help you.
Absolutely. And I think that's a really good point that you made, is that we're not saying that a forbearance agreement is always bad. Mm-hmm. We're not saying that, guaranteeing something is always bad, but, I think it's really important to know what it is you're signing it away before you do that. Because sometimes you're right. I mean, that's something necessary in order to get that time, to get that new financing, to get to change whatever is affecting the business. But I think it's really common when people sign stuff kind of in the throes of the situation, and it really affects things down the road.
Yeah, and sometimes, as from the lender's perspective, sometimes that additional time that you're giving out can be fairly detrimental. Like, so when you're entering into a forbearance agreement, you want to make sure that you're doing a bit of due diligence as well. For example, let's say you're working with a business, it's always nice to be able to do a form of a credit check, or look into whether or not there's any prime charges from the government of Canada, or whether or not there's any outstanding payroll tax or anything like that. So if you are secured, you want to make sure that you preserve that security position and move somewhat quickly. But again, that's the nuances of all these different situations. So they can work. They are great tools, but yeah, I think we can definitely help you out on that one.
So I guess the process would be you come in, talk to somebody like Shane, and you're going to take a look and see what the whole situation is, what the legal rights are, and then you'll make a recommendation.
Yeah,
there.
absolutely. And some of it is information that we're just going to have from going to court all the time. Like, we're litigators.
Mm-hmm.
You have an idea as to what an honest turnaround time is for, filing a court application, advancing a proceeding. Sometimes you hear, look, we're going to initiate a claim and it feels like the world's crumbling, but we see this stuff all the time. We have a better sense of, okay, well, just because you file a claim doesn't mean they're going to have a judgment right away. What does it mean when they do have a judgment? How long is it going to take? And within that, you can also build a strategy. So if they say, well, enter into a forbearance agreement or else we're going to pursue a judgment, well, you might know, well, that might be 6 months in and of itself, regardless if I enter into the forbearance agreement. So let's kind of negotiate with a sense of perspective.
Yeah, that's a very good point. And I think that's one of the things I wanted to get into a little bit is the difference between just a lender or a creditor coming after you for a debt and somebody coming after you with secured debt. Because what a difference,
Yeah,
you're and what you said is absolutely right. Being threatened with a lawsuit, being sued even doesn't necessarily mean that a judgment's going to happen right away, unless you sign something. But having coming when a lender or somebody with some secured debt is coming after you, that there's some different considerations there. But still, there's things to look at.
Yeah, absolutely. You want to be careful. I mean, especially in some of the larger sort of the commercial context is, if you've entered into, let's say, a credit facility with a major bank, a lot of the time in there, they're going to have relief relative to pushing into an automatic receivership upon default. So they're going to have rights and opportunities available to them to try and exercise or realize against their debt that you want to be careful of. Like when you're talking about receivership, a lot of the times that means you're losing the reins of your company, that the interest changes from the shareholders to the receiver, and the receiver is going to work for the creditors, and things can get wound up rather quickly. So when you're dealing with sort of the larger commercial context, and even any lending in general, you want to look at the contract, have a lawyer look through it, and kind of give you, like we've said, like this strategy about, okay, well, how can we get you out of here if we can, and if we can't, how can we get you out on the best outcome for yourself?
Yeah, that's a good point. I mean, we can't guarantee we're going to get somebody out. I mean, things are, if things get to a certain state, really what we're looking for is to try and come to an agreement or get you enough time to get yourself out of it. But yeah. I mean, at some points, it comes a point where it just isn't. There isn't anything we can do. I mean, Some of the things you talked about, the Company Creditors Arrangement Act, it's pretty exotic for probably a lot of our listeners, but it's out there. But at some point, there's always working with a bankruptcy trustee too.
Yeah, absolutely. We team up with them fairly often. Yeah. I mean, they're going to be the experts in the field and let you know sort of what transactions are subject to what requirements, how to best move through it. I could list a couple guys in the buildings next to us here who do a great job.
Yeah, absolutely.
So yeah, I mean, aside from that, I think first and foremost, if you find yourself in a position where, let's say you've got the wolves at the door, the creditors breathing down your neck, the realities of the economy today, you've got AR that's outstanding, you don't necessarily know what to do, but you're feeling the pinch. I think, the first knee-jerk reaction is I don't want to incur any additional costs and I want to try and figure this out. We want to keep things tight. Not that you want to, ring the alarm bells on everyone, but I do think it's very prudent to give a call to your counsel, whoever that may be, and have a sit down with them or, their team, whether they bring in a trustee or not, and really take a review of your situation, what debts you're looking at, what accounts you're looking to call on, and really try to exercise the time and opportunity that you have available. And then when you're looking at the time and opportunity that you might not have that you're looking to purchase, making sure that you're purchasing it for a fair deal.
Yeah, and having a reason, I think, to purchase that time is important too, because I mean we're not just going to sit there and try and delay things if there's an inevitable result at the end of the day. We want to know there's something there, but very often it's just a matter of getting some financing. Yeah,
absolutely. And in the commercial context, I feel like there's a certain level of sophistication. Like most people have a better business sense than I do about what's going on out there. So as long as you have a somewhat realistic conversation. You know, you don't want to kick someone while they're down, so to speak, but taking a look at their legal position, where they're at financially, and just sort of their overall business circumstance, and then, you know, trying to develop a plan from there, I think is your best bet.
What is your experience with real commercial lenders like banks and that? So if we've got, when our clients, something bad happens and we go into default, and we can talk about things like reinstating mortgages and that, but if that's not there, do you have any experiences in dealing with big commercial lenders?
Yeah, not that I'm the most experienced lawyer on the block, but in the experience that I do have, it seems to be a bit of the luck of the draw. Some of the larger lenders across the nation are very quick to call their debt, difficult to deal with, and I think they have somewhat of a prerogative to make sure that reputation is known. Even if it means, them taking a bigger hit than they otherwise could get from someone that they're dealing with. On the other hand, sometimes you're dealing with a local credit union, much more willing, in my experience, to work through it with you, much more looking to realize as much as they can in the long term, and then, continue to build a relationship with whoever they're dealing with within the community. So seems to vary.
Very much so, doesn't it? I mean, there's certain lenders are just so aggressive. It seems like at times they're almost acting against what they could get. If they
absolutely
chill a bit and let's take a look at the whole thing holistically. But others, are much more willing to try and work through it.
Yeah, and unfortunately, I mean, it's a bit of a luck of the draw. Like it's tough to tell from a consumer or customer's perspective of who's taking out the loan as to what kind of treatment they're going to get on default, or vice versa from the lender's perspective. It's tough to be able to determine what the prospect of someone is repaying their debt. So again, the realities of the situation are what they are. The law is what it is, and we can only help, as much as we can, but there's going to be some variables in every situation, but making sure you got the best pair of gloves on for the fight, I think, is a good idea.
Thank you, Shane, for showing up and giving such wonderful tips to our businesses that have run into a bit of financial downside. Hopefully you've learned something, and until next time.